All right, so sorry for the break in transmission. I was simply trying to explain the further obligations of the party slash the any other business clause. So the essence here is any information that is very important or that is vital that has not been mentioned in any of those clauses or covenants that I just mentioned. You can always include them in the any other business clause. Now, what follows next is what is known as a non-disclosure of information slash confidentiality clause. I'm sure this is one clause that even if it's not written, I mean, why would you want to disclose the vital information, the privileged information that you have communicated to one another to a third party? So, but then every form of agreement is always best to be reduced into writing, especially if it involves property transactions. And this actually is not just for the sake of saying. It actually has a legal backing, and a very common one. It's Section 4 of the Statute of Frauds, which simply knows that any form of agreement that I'm not saying it's exactly how it is, but any form of agreement that relates to property of some sort should always be in writing. Now, given that this JVA is to develop property, obviously it has to be in writing, and literally every other information, every discussion, every communication should always be reduced into writing. Not necessarily for the form of proof, but for the purpose of record keeping. So the next point is what is known as the termination clause. Now, this clause describes when the agreement can be terminated, either willfully by both parties or upon default by either. What that means is termination here simply means the JVA coming to an end. So there are three reasons why a JVA can come to an end. Number one, it could be that both parties have executed all obligations, with reference to the JVA, so there's no need for it to still be in existence. The second point could be that even while the JVA was going on, and maybe both parties get cold feet, or there's an issue that both parties have decided that, okay, there's no points going on with this transaction because let's put an end to it here and count our losses. They will go. I mean, it gets terminated at that point. Or where a party fails to adhere to the covenants slash clauses in the agreement. Obviously, when the party decides to unilaterally misbehave, you wouldn't expect the innocent party to keep adhering to the same agreement that the other person is willfully disobeying or not listening or not adhering to. So in such instances, the JVA could be terminated. However, where it is willful, usually a length of notice is given to the other party to put them on notice that, okay, this JVA will be coming to an end at so time, so put your house in order and things like that. The next point is known as the duration clause or covenant. This covenant usually states when, that's the period that the JVA is to last. 2 years, 5 years, as the case may be, depending on the development project taking place in that property. The next covenant is known as assignment clause or covenant. Now, this ensures that no party unilaterally assigns or delegates any right or obligation to another person without prior consent. For example, even this particular clause protects what is known as privity of contracts. That's the parties that are, those are the ones that are involved in the agreement. So if party A enters an agreement with party B, obviously any form of obligation that party B has is to party B and party B is to party A. So both parties cannot go outside such agreement. So that's why it says that if there's any need for you to assign or to perform any rights or obligations outside the party to that agreement, always put the other party on notice. Now, the next clause is known as the waiver and forbearance clause. Now, the essence of this clause is simply that if a party fails to enforce his or her rights, either clearly stated in the JVA or antecedent to it, now it does not mean that he or she has waived the enforcement of that right. It could simply be that he or she does not want to enforce that right at that very moment. The next clause or covenant is known as the governing law and arbitration clause. This simply, this even the name is what it is. It governs it points out the laws that governs the agreement as a whole, the law or regulation to be used to settle disputes, and the length of notice to be given when disputes arise. Now, the next clause or covenant is known as severability clause. Now, the essence of this clause is that, sometimes, no matter how careful one may be in drafting a contract, there may be some times where either party may consciously or unconsciously insert unreasonable clauses. Now, the essence of this clause is to know that where such clauses exist, it will not nullify the agreement as a whole, but the only thing that will happen is that that section of it or that particular clause or provision that was deemed unreasonable will simply be set aside. And in addition, it could state that both parties in trying to replace that particular clause or covenant may agree with themselves on what should be properly placed there. The next covenant is what is known as a force